I didn't want to start. If they really walk around it to get to the window. Yeah, it's cold one. I don't like it. Alrighty, welcome back from break, everybody. Such balmy spring break weather we have on our second day of spring here. So just to keep us updated with what's going on syllabus wise, we're right on track with the schedule. So today we're going to finish talking about criminal assessments. Your midterm is due on Thursday if you haven't turned it in yet. So again, remember, those are the short answers. Download the Word file, respond to each question is the easiest way to do it so that I can see your response to each question. I don't have to hunt for it. And then re-upload it. So that's due midnight. I think Blackboard makes me say 11:59. So the next thing you have coming up in about 2 weeks from today is your interview paper. So this is someone either from the organization where you're volunteering, or if you used an old organization, it can just be someone who's doing something related to psych and the law you're interested in. And that's cool. So the next topic we'll talk about is civil assessments. Those are like custody evaluation things along those lines. But today we're going to keep talking about criminal assessment. Oh, and I want to give you a quick update. I don't remember if they released them to you today or tomorrow. But I did do your midterm progress reports. And if you have a 0 for something in there, it can definitely be changed, updated. So like a bunch of folks in this class just forgot you're supposed to have a meeting with me. If you make one, I'll change the grade, no big deal. But it's only through Friday. I submitted them Friday. So if you turned in anything over the weekend or yesterday or today, it's not in there. These don't go at all into your GPA or anything like that. It's really just a benchmark for you to look and go like, okay, what do I need to catch up on? So if you have any questions, feel free to email me and or to just reach out to me. And grab me before or after class, set up a meeting, whatever works for you. So I am just gonna make sure I check in our folks who joined Zoom a little late. And we'll go ahead and get started, dive right in. And I apologize. The assessment section is a lot of me talking, and I don't like to do that in general. But it's sort of the only way we can cover this well. So I promise after another week of me just talking at you, we're going to do a lot more interactive stuff. So all right, I'm going to hide the captions so that we can use the better Google ones on here. Okay, so we had gone through competence, and one of the things I wanted to circle back around to, since we're going to start talking about that today, is when competence and not guilty of a reason of insanity overlap. And so it is possible that the same person and their legal team could try to argue they're incompetent to stand trial. But if they can stand trial, then they're not guilty by reason of insanity. So if that happens and you're a clinician who gets those referrals, you will often get them at the same time. They'll be like, okay, just, you're going to do the eval on this person, have fun. But the reports and actually a lot of the assessment will end up being pretty distinct. So you should address competency first, just because if the person's not competent to stand trial, there's no point in going forth with an NGRI, right? Because we're not going to have a trial at that point in time. And you also can't conflate them. So you can't say, because this person's incompetent to stand trial, they were insane at the time of the crime. We're talking two different times. Competence to stand trial is right now, person in front of me, how are they doing? Not guilty by reason of insanity is at the time of the crime. So sort of detective time travel almost work on the part of the psychologists. And a key element of your response is the person's account of their behavior at the time of the event. And one of the things we're going to talk about as we start talking more about not guilty by reason of insanity as a plea is that when you're saying you're not guilty by reason of insanity, inherent in that is saying, I did the crime. So you are admitting guilt. You are admitting, I'm the one who murdered that person, stole from them, what have you. But you're saying, but because I was mentally unwell at the time I committed the crime, I shouldn't be held accountable in the same way. So for and this is a plea. So this isn't something that would necessarily just pop up. The judge wouldn't be like, oh, they're NGRI, right? The person and their legal team say, we're going to make this plea. We're going to plead not guilty by reason of insanity. So you're admitting that you committed the crime, but you're maintaining that you shouldn't be held responsible for your actions because at the time of the events, which again could be weeks ago, more likely months or years ago, because our justice system is not that efficient, you met the criteria for insanity for that particular jurisdiction. One of the things we'll see, and we've kind of talked about this with some of the legal cases, is that the criteria for who qualifies as not guilty by reason of insanity varies from place to place. So again, the defendant has to be the one who raises it, the person who's accused of the crime. They and their legal team are the ones who raise it. And when is it raised? Early in the trial. It's often raised at the time of arraignment. So this is really early. You can also enter multiple pleas, which is really interesting. So you can enter not guilty and not guilty by reason of insanity, which is sort of contradictory, right? But people do that sometimes. And again, this can be really tricky if you decide to go this route legally, because NGRI is technically an admission of the crime. So even if NGRI is dropped later and they're like, no, that person wasn't insane at the time they committed the crime, evidence of crime commission may have already been presented as part of the NGRI argument. So you might be sort of like shooting yourself in the foot, right? And the assessment, and this is why this is so hard for psychologists, the assessment you're trying to get at is at the moment of the crime, the moment of the act. And obviously, you can't assess whether they were sane or insane at the time of the crime if they say they didn't do the crime, right? And it's difficult to assess in general because our instruments aren't really structured to like time travel. And so essentially no one will be found not guilty by reason of insanity if they don't admit to committing the crime. So how many people actually plead NGRI? So when you do surveys, community-based surveys, people believe about a third to a half of people charged with crimes try to plead not guilty by reason of insanity. And most people in the community see it as crap or a cop-out. In actuality, what would be your guess of the percentage of how many criminals attempt an NGRI plea? It's not a third or a half, I'll give you that hint. It's less than that. 10%? Any other guesses? Okay, 10% people are feeling, it's actually 1%. So it's super rare. And why do we think it's 10%, 33%, 50%? Because we see it so much in the media, right? When someone does have an NGRI plea, those cases are covered. And also crime shows, crime movies love a good NGRI, right? It sort of makes it more fun. So yeah, and that's 1% of all criminals even attempt an NGRI plea. And the success rate, so people who are found not guilty by reason of insanity, is only 25% of that 1%. So we're talking 0.25% of people who commit crimes and go through the legal system are ever found not guilty by reason of insanity. There's some pretty high criteria to meet it, and that's part of it. And there may be an underestimate here of the proportion of cases in which significant psychological impairment might actually be part of the criminal act, because not everyone tries an NGRI plea. There are times when it's less clear, right, whether their psychological functioning was impacting it or not. So with plea bargaining, what can happen is it would never actually go to trial. They would enter a plea of not guilty by reason of insanity. They would get a psychological evaluation. And sometimes this is referred to as an evaluation of criminal responsibility. And then there's some resolution without a trial taking into account the agreement that this person met criteria for insanity at the time of the act. Or sometimes what will happen, whether or not they're even considering an NGRI plea, is they'll plead guilty to a lesser charge in hopes of getting less time. Or in people who might plead NGRI, they might plead guilty to a lesser charge with treatment instead of jail. And so I think I'm going to bring this back up again later in the lecture, but I just want to emphasize this right now. If you're NGRI, that does not typically mean they just let you go free. So very similar to competence to stand trial, there's typically some sort of remediation, sentencing to a mental health facility. So for example, does anyone know who John Hinckley Jr. is? So he's the guy who tried to assassinate President Reagan back in the day. I think this was before I was even born, so it's been a while, maybe when I was young. And he was doing it because he thought he would impress Jodie Foster, the actress, and that she would marry him. Well, we didn't know then that Jodie Foster has since come out as a lesbian, so it would have worked anyway, right? But he actually shot President Reagan, and I think at least one, maybe several of his Secret Service members. And in fact, there was an interesting case a couple of years ago where one of the Secret Service members died fairly recently. And there was talk about sort of reviving his case because there was a long, slow death from this bullet wound, essentially. But I don't think anything ever happened with it. So he was clearly not mentally well. He was found not guilty by reason of insanity. And so again, this crime happened in the 80s. And he, I want to say maybe 4 or 5 years ago, just got out of that mental health facility. He was in there that entire time. And the only reason they released him is that his mother was still alive and was willing to sort of take custody of him. So last I heard, he actually lives in Williamsburg. He's from this area and was working as a gardener at a church. And the church sort of said, part of our ministry is, you know, to try to accept everybody and support everybody. So they hired him, which was really interesting. So again, this doesn't mean you're going scot-free, right? So he was in that facility for like 30 years. All right, so how do we decide who's insane, what's insane, what are the criteria? Well, there's a lot of different history that comes into play to what our modern criteria are. And some of these have really silly names. So I'm going to give you the heads up. And one thing I think I said previously, but I'll re-emphasize here, is that insane is a legal term. Nowhere in the DSM-5 are you going to see like insane, code this, right? We're going to be diagnosing much more specific things. But for the legal case, they kind of don't care what their diagnosis would be, just whether they meet these criteria for insanity or not. So the wild beast test is where you're not responsible for the crime if you had no more control over your behavior than a wild beast. Right, it's not very precise criteria, right? And that's the problem in a lot of these tests, early tests, right? Is like you would sort of make a judgment call, right? There's no good test for that. Then there is the M'Naughton test. And this is from the case of a man who suffered delusions and actually killed the secretary of the British Prime Minister while he was attempting to kill the Prime Minister. And the Prime Minister in Britain is sort of equivalent to our president. And the M'Naughton test is the standard of knowing right from wrong. So the standard states that people are insane at the time they committed a crime if, because of a mental disorder, they did not know the nature of the act or did not know right from wrong. So you're shooting someone, but you think it's going to be like a video game and they're just going to pop up with another life, or you don't understand that doing that is wrong. And this test is actually still used in all cases tried in federal court in the US, and about half of cases tried in state court. So 28 of 50 states still use the M'Naughton test. So again, the idea is because of some mental disorder, you don't know the nature of the act and or you don't know right from wrong at the time of your crime. The Bronner rule is from the Moral Penal Code, again, in Great Britain. We get a lot of our, because they were our colonizers, we get a lot of our legal influence from the British. And the Bronner rule states that if a defendant is not, that a defendant is not responsible for criminal conduct, if they, and this is a long sentence, so bear with me while I read it. At the time of such conduct as a result of a mental disease or defect, lacks substantial capacity to either appreciate the criminality, wrongfulness of their conduct, or conform their conduct to the requirements of the law. So basically pretty similar to McNaughton, but it's essentially, rather than being about right and wrong, it's, do they understand it's against the law, essentially. And I do have to say, I'm updated that language to make it gender inclusive. The original language just uses I want to say the royal he, but the inclusive he, right? So they. Then there was something called the irresistible impulse test. And this was emphasizing the inability to control one's actions, that you were considered insane if you committed the crime in its uncontrollable fit of passion. Again, not really clear criteria here. And so this one's not really used. Just like the wild beast test, not very clear, so not really used. Then there's the Durham test, and this is from Durham v. US in 1954. We're flashing back to Judge Bazelon that we talked about in our very first lecture, who was the mental health oriented judge, and he allowed a psychologist to testify as an expert witness in this trial. And again, that was sort of groundbreaking because before that, people were arguing, oh, you have to have an MD to testify, even though psychologists often have more specialized knowledge with a PhD than someone with an MD. And so the Durham rule argues that to establish not guilty by reason of insanity, the person, number one, you have to show the person has a mental disease or defect. So you do have to show some sort of mental disorder. And number two, you have to show the criminal act as a product of that mental disease or defect. And so this was later refined in another case, McDonald v. US, that you needed to prove that they were substantially impaired because of the disease or defect. You were essentially not just like excused from a crime because you had a mental disorder. And this was overturned in this US versus, sorry, that should be Browner, not Boroner. Oh, typos. I've had that in my slides for several years, so that's awesome. And they reverted to McNaughton. They basically said, like, I don't know how helpful it is to know the person has a disorder. There's the American Law Institute test. People are not criminally responsible if at the time of a crime they had a mental disorder or defect that prevented them from knowing right from wrong and or from being able to control themselves and follow the law. And this was in response to a call for tougher standards following the John Hinckley Jr. case that we mentioned previously, and that's actually the next case we're going to talk about. Okay, so yeah, I was alive, but under a year old. I was born in 1982. So the John Hinckley Jr. case, again, he attempted to assassinate President Reagan to impress Jodie Foster, and he was also stalking Jodie Foster. I should have mentioned that. And he was found NGRI, and again, had a very long-term criminal commitment to a mental health facility. And it was, however, sparked outrage because he was the president of the United States. Someone attempted to assassinate him. It's hard to see now, but Reagan was actually a very well-loved president at the time that he was president. People felt like he was doing good things for the country. He was also a popular actor beforehand, so people liked him for that reason. So to have, you know, what they saw as a national treasure, you know, attempted to be killed, and in people's minds, no one got punished. Again, even though John Hinckley Jr. was in civil commitment for 30 plus years, that really led to this call for stricter standards. So then in 1984, there was the National Defense Reform Act. And this brought us back to McNaughton. Again, we keep bouncing back to that. Some sort of severe mental disease, and the crime is a result of it. And that the person, as a result of that mental defect or disease, doesn't understand the nature and quality of the wrongness. The most important part of the National Defense Reform Act is the burden of proof for NGRI is on the defendant, on the person who's claiming they're not guilty by reason of insanity. So essentially, you are considered sane until you're proved insane. It also established the equality of psychologists and psychiatrists as expert witnesses. So that is codified into law. It's not just based on case law now. And the American Psychiatric Association, so this is the national organization for psychiatrists, people with MDs who work in mental health, said that you should only find people NGRI if they don't know right from wrong at the time of the crime. Bless you. And so they argued that the inability to control yourself and the inability to follow the law wasn't sufficient. They also had to not know right from wrong. And their argument was, a lot of people can argue, oh, I couldn't control myself at the time. It was a fit of passion, right? And again, this keeps bouncing us back to Manon, right? So that's mostly the standard of the land. All right, so for that 0.25% of people who are found not guilty by reason of insanity, who are they? What characteristics do they share? So considering that confusion is a major feature of the inability to tell right from wrong, and that it's also a major symptom of schizophrenia, it's not surprising that 2/3 of all those who are found NGRI would be diagnosed with schizophrenia. About 50% are Caucasian, 86% are male. I would say this doesn't necessarily reflect higher rates of mental illness among men as much as it does that men tend to commit these violent crimes more often. And I think a lot of that, it sounds weird, a lot of that has to do with the social acceptability of men committing these crimes, right? It's considered more socially acceptable for men to be violent than it is for women. They're supposed to be more like catty and backstabby. And then the mean age of someone who's found NGRI is 32. All right, so you're a psychologist, probably working for the courts or maybe an independent contractor, and you are assigned an NGRI assessment. What the heck are you gonna do? Well, the first thing you're gonna do is a thorough record review, because again, you're being asked to assess this person in the past, maybe a couple months, maybe a couple years. So you're going to try to find as much information as you can about that person around the time of the crime. But also you might even dive further back just to get more of a, like, what is this person's story? So you might ask for school records. Look at if this person has a criminal record. Police reports become especially important because they provide an account of that person's behavior close to the time of the crime. So if the police report from when they interviewed the person, they're like, he seemed to be talking to things in the walls. You're like, okay, that sounds like some psychosis was going on, right? Also, if they have previous psychiatric and or mental health history, you would try to get those records as well. Then you want to interview, and here, very similar to other forensic assessments, you want to interview lots of people. So obviously the defendants, but also their family members, maybe their close friends. If the victim survived, right? If it wasn't a murder, try to interview the victim, any witnesses to the crime, but also other people who just knew the person at the time of the crime, fellow employees, employers, right? Their bosses, neighbors, although we all know from the news that neighbors aren't always the best at this, right? I feel like every time there's a violent crime, people are like, he just seemed like the nicest guy. I had no idea, right? People are good at hiding stuff. And if you can find people with whom they interacted on the day of the crime, those are like gold, right? Because those are people who saw them that day, can give you an indication of what their mental state would have been. And then you're going to do some traditional assessment, psychological tests. The problem with these is they will give you a nice baseline, but these are structured so that they're testing how the person is doing right now, right? So you can do things, and actually it's recommended to give the Wechsler Adult Intelligence Scale. This is a very stable instrument. They retest reliability, which just means if I give you an intelligence test now, and I give you an intelligence test in a year, the correlation between your scores would be really high, 0.95. The highest you can get is 1, okay? So it's very stable over time. This is very important if the argument is they're not guilty by reason of insanity because they have low intelligence, for example. That's something you need to formally test. And then they also recommend an MMPI. Now, I have MMPI 2 here. I'd be interested to see if they're recommending the 3 yet or not. The 3 just came out about a year and a half ago. And I know they've done tons of forensic research with it, but like often you want something with years of research behind it. So it'd be interesting to see if people are still using the 2 or have switched to the 3. I'll have to try to poke around and see if I can find out about that. So the MMPI has some advantages in that it has validity scales within it. And some of these are questions that even someone with severe psychopathology, so someone with really severe schizophrenia, still wouldn't endorse, right? So if this person is like, oh yeah, that and that and that, they might be malingering or faking. So unfortunately, that only identifies whether they're malingering now, right? Not their mental state at the time of offense. However, it can be helpful if you find out they're not malingering, but they do have serious psychological disturbance. So for example, something like paranoid schizophrenia. Once you're diagnosed with that, even if it's well controlled by medication, you kind of always have it, unfortunately. It's stable over time, right? So if you're finding indications of that, it can be really helpful in making your case. But then there are also instruments that have been developed specifically for NGRI assessments, just like there are for competence to stand trial. The most commonly used one of these is the Rogers Criminal Responsibility Assessment Scales, or the RCRAS. Gotta love it. For this, the clinician provides the data based on everything we just talked about that clinicians do. All the interviews, all the record review, all the traditional assessments. There are 25 scales, but each scale is only 1 item, which is typically problematic when we're looking at the strength of an instrument. And it rates aspects of behavior. And then those 25 scales are condensed into subscales for malingering. There's one that's called organic mental related. It's basically, is it a brain problem? Did they have a traumatic brain injury or a tumor or something like that? Major disorder, cognitive control, which is did they know right from wrong, and behavioral control. It's useful for organizing your data and can serve as a guideline for data collection itself. However, my professor who taught me about psych and the law in grad school referred to it as pseudoscience, that there's not a lot of great data to back up its use. And you're basically just making rankings and using a decision tree, and it's all based on clinician intuition rather than like hard data itself. It gives you 3 outcomes: sane, insane, or no opinion. So one of the reasons why Jack called this pseudoscience is that when, just like we talked about the test retest a minute ago, that we want those to be pretty high if we're going to look at something over time. One of the other things we look at in psychology is if I give this person the test and then my friend who works at the Naval Hospital in San Diego gives this person the test, that person should score about the same, right? And again, very similar to test retest, the higher that number is, the closer it is to 1, the better it is. Unfortunately, we call that inter-rater reliability, and unfortunately, that is all over the board. So some of the subscales, you'll get close to 1, but some of them are only at 0.45, which is lower than chance, right? It's lower than flipping a coin. So ideally in psych, we want a minimum of 0.7 for research. And if we're doing something like this, where we're making decisions about someone's life, we want 0.9 or above, right? So for that reason, this should be used again, maybe to guide, to make sure you're checking all your boxes, but probably not to just like make the decision. All right, so then you got to write your report, right? You've done all this. You've got to actually put it together and formalize it. So the first thing you're going to do is mention your referral source. Is this court ordered, right? Did you get this from the judge? Is it from the defense attorney? Is it from the prosecutor's office? Then you have to talk about the fact that you discussed with the defendant and their attorney who will see this information, and that it won't be held confidential, right? It's not like a client relationship, that this will go to whoever ordered it. And if it's, you know, going to the courts, it's going to be entered into public record, right? So you want to give informed consent and confidentiality or lack thereof, and say that knowing this information, the defendant agreed to participate. Because again, remember, the defendant is basically saying, I committed the crime to undergo this evaluation. Then you list all your sources of information, you know, your interviews, your record reviews, the tests, you list everything you use to get your information. Then you're going to give some histories, social history, medical history, mental health history, maybe educational history, history of substance abuse, criminal or legal history, mental status at the time of the evaluation. Again, this doesn't give you what happened at the time of the crime, but it does tell you, was this person properly able to engage with the process? You also, if this person has been being held prior to trial, you want to talk to the folks over at the jail. How has this person been acting? Have they been acting perfectly fine? They've been going over to the library and reading books about schizophrenia, right? Or have they been in their own world, seeming to actively hallucinate, right? Things along those lines. Then you want the defendant's account of the alleged crime before, during, and after the crime. Then you'll interpret the data you got from those records review, and particularly from the tests. And you really want to focus in on malingering here, right? Is this person trying to pull a fast one? And then opinions about their mental status at the time of the offense. And this is the most important part. And what you're trying to say is the crime, is the act related to their mental status? Did they understand what they were doing? Did they know it was wrong? Now, the interesting thing is you can give opinions about that, but the vast majority of the time you are not allowed to give an opinion about the ultimate issue. So you can basically say, this person did not understand what they were doing. They did not know right from wrong, but you are not allowed to follow that with a sentence that says, therefore, there should be found not guilty by reason of insanity. Because the idea is that is up to the trier of fact, typically the judge, to decide. So you are just like pointing them in that direction. So in addition to Hinckley, there are a couple other famous insanity defense cases. A big one is David, son of Sam Berkowitz. There are movies about him. He was a serial killer in New York City, and he argued that a dog was sending him messages to kill just by barking. He was found guilty, even though 2 different psychiatrists diagnosed him as psychotic, because they couldn't say that that psychosis is what caused him to do the crime, or not knowing right from wrong. And it turns out that was the appropriate ruling because he later said he just made up the stuff about the dogs, that he wasn't actually having delusions or hallucinations. Andrea Yates is a much more sad case. So this was around 2005, 2006, she drowned all of her children. I actually got the chance at a grand rounds, one of the hospitals I worked at in grad school, to see a psychologist who had assessed her talk. And, he had permission to talk about the case, obviously. And what had happened is that she had a very bad history of postpartum depression and postpartum psychosis. This can happen. There's a whole spectrum of postpartum disorders. And her previous child, the doctor had said, we should tie your tubes because you can't keep having kids. This is not good for your mental health. And her husband was a fundamentalist and said, no, we have to have as many kids as God tells us to have. And so would not let her get that surgery. She had another child, experienced the postpartum depression and psychosis, and killed, I think they had like 5 kids, killed them all. And so it was preventable, is the really sad part. So in the first trial, she was found to have a mental disorder, so kind of like similar to Son of Sam, but still found guilty. And then there was a retrial in 2006, and she was found not guilty by reason of insanity. Oh yeah.
Right. So I took a class in high school. I forgot if it was like for English or, but we did a mock trial or whatever.
Mhm.
And it was on the Andrea Yates case, but it was also on the Susan, I forgot her last name. But she also killed her children, and she wanted to plead not guilty by reason of insanity because she said that God had told her to kill her children. So I was like, they were trying to argue which one was more like
Convincing.
yeah,
Yeah. Yeah, that's so interesting. Yeah, because I mean, we don't have trials because unfortunately most of these people also die. But you made me think of cults, right? So in a lot of cults, unfortunately, there's this idea, we sometimes call it like death deniers, that they think we're gonna die and we're gonna go to like a different plane of reality. Like this was Heaven's Gate, this was Jonestown. The idea that like when we die, we're going to like either somewhere in outer space or heaven or what have you. And so there are a lot of cases where people say, oh, well, God or our religious figure told us to do this, and they also kill themselves. But yeah, so that's a really interesting thing. Yeah, it makes me think of one client I saw in grad school who had symptoms of both mania and depression. And she told me that God told her to cheat on her husband. And I was like, hey, I'm not like a biblical scholar, but even I know the 10 Commandments, right? Like, again, I didn't like argue with her, but I was just sort of like, no, that probably didn't happen, right? Just based on my basic understanding of religion. Yeah. So in Andrea Yates's case, she is a maximum security state mental institution, very similar to Hinckley, and probably won't get out for a long time. So people who are found not guilty by reason of insanity typically have a record of prior arrests or convictions, although that does not exceed the rate of other felons necessarily. They tend to come from lower socioeconomic status. I think there's a couple reasons for this. One, unfortunately, people who are rich, in particular high socioeconomic status, can evade the law, right? Go live in a private island somewhere. But two, and probably most importantly, people who are rich can afford to get mental health care, right? And oftentimes people who are impoverished cannot. And so I think that's a big difference there. They tend to have a history of psychiatric hospitalizations. And often they've previously been found incompetent to stand trial. So maybe they were found incompetent to stand trial, they went through the remediation, got to the point where they could understand what was going on in the trial, because that's all that's really required for competence to stand trial. But then they find out, no, they're in GRI. So obviously there are some problems with the insanity defense. There's a fundamental difference between the law and the science of human behavior here. We're looking at psychology as a science, but also sociology, anthropology, what have you. The law assumes that individuals have free will and are generally responsible for their actions. However, research from the sciences supports the notion that psychological and physical forces affect human behavior, and that people may not be able to control their behavior as much as the law portrays. There's also uncertainty of scientific knowledge, particularly about psychopathological behavior. So during a typical insanity defense trial, the testimony of the defense clinicians differs from the testimony of the clinician hired by the prosecutors. And I think there was a little bit of this that went on in the Johnny Depp Amber Heard trial, right? Where like the psychologists were disagreeing. It wasn't like not guilty by reason of insanity, but it's like, unfortunately, if you pay some mental health professionals enough, they will find what you want them to find. Technically, ethically, we're not supposed to do that. We're supposed to just look at the data objectively. But there are people who are willing to kind of like bend the science, and that's partially because the science of psychology is so young. It really only started as a science in the late 1800s, right? And so we still have a lot to learn. And the jury then has to weigh the claims of these two experts who disagree in their assessments. And some people will see this lack of agreement as evidence that the knowledge in some areas is too incomplete to be allowed to influence important legal decisions, so that hurts the mental health profession in terms of our ability to be seen as credible expert witnesses. One of the most often heard criticisms of the insanity defense is that it allows criminals to escape punishment. Again, as we've seen with a couple of the cases we talked about, these people aren't just like going free on the streets. They're often in these high security mental health facilities for either the rest of their life or at least a long time. And there's also the problem of time in general. Again, and I've said this over and over, but it just really bears repeating, that psychologists and psychiatrists, when they're presented with these assessments, are asked to determine if people were insane at the time of the crime. And this is very difficult to determine, and we have very few instruments that help us figure this out well. But there are other options besides just not guilty by reason of insanity. You can be found guilty but mentally ill. This verdict states that the defendant is guilty of committing a crime, but is also suffering from a mental illness that should be treated during their imprisonment. This is not a substitution for NGRI. It's basically just saying, make sure this person gets some treatment. It's controversial for that reason because it's a little confusing. And it basically says they suffer from a mental disorder, but they're still responsible for the crime. Then there's guilty with diminished capacity. Here, a defendant's mental dysfunction is viewed as an extenuating circumstance that the court should take into consideration in determining the precise crime of which they are guilty. For example, a defense attorney could argue that their client, as a result of the mental dysfunction, could not have intended to commit the crime. And then the person could be found guilty of a lesser crime. So for example, murder one, first-degree murder, requires premeditation, planning, right? So then you could argue, well, this should be manslaughter because this person couldn't have planned. There's another verdict, again controversial, it's mentally disordered sex offenders. So these folks are convicted of a criminal offense, seen as responsible for their actions. And they are committed to mental health facilities like people with NGRI, criminal commitment. And this reflects the belief that sex offenders are psychologically disturbed. Also, this is partially made to protect sex offenders from the abuse they receive from other inmates in prison. Even hardened criminals who have murdered people really don't like when you sexually assault kids. And so sex crime, people who are convicted of sex crimes are often physically abused while they are in prison. And you could argue sort of the morality of that, right? But the law says that we're not supposed to have, right, undue punishment. States have been getting rid of this, however, because it can be difficult to apply. And due to public outrage, there's less concern about the rights and needs of sex offenders. All right, another thing you can be asked to do during a criminal trial is a risk assessment. And you can do this in a whole bunch of different ways, actually. So what is it? We are evaluating the likelihood this person will be violent in the future, and in particular, violent towards other people. So Barefoot v. Estelle in 1983 permitted the introduction of mitigating circumstances and said that psychiatrists can testify about the likelihood of future violence. And this was the first time that it was clearly permitted to talk about what this person might do in the future. This is a factor in death penalty evaluations. It's not very accurate, but you can still testify about it. Shell v. Martin, 1 year later, rejected the contention that it's impossible to predict future behavior and used risk assessment in a bail situation. So they used professional testimony concerning future violence in a pretrial hearing. And the court said, yeah, that's okay. That's helpful information to the court. And then Kansas v. Hendricks in 1997 said that you can use risk assessment for civil commitment and for prediction of not only like, will this person kill someone, but the prediction of sexual violence. Overall, these cases show a belief that experts have the ability to testify concerning future prediction of violence. So when are experts asked to make these predictions? You always do this in a normal clinical practice. Part of a standard intake is assessing for danger to themselves or to others around them. In death penalty cases, either the defense or prosecution may ask for a risk assessment to support their side. In civil commitment, so someone hasn't committed a crime maybe, but you think they're a danger to themselves and others, you want to involuntarily hospitalize them. One of the criteria is dangerousness to yourself or other people. Pretrial detention, bail, things along those lines. Pre-sentencing evaluations. Will there be repeated violence? And this happens a lot whenever a crime itself involves violent behavior. And also whenever there's a question of releasing someone, whether that's someone from the prison system, are we going to let them out on parole? Or are we going to release someone from civil commitment? So I'm sure John Hinckley Jr. went through a very thorough risk assessment before he was released to his mother's custody. The core of all this is the protection of society. The idea is we now know this person has the possibility of being violent, right? Do we need to keep them in custody to protect society? And the Tarasov case that we talked about at the beginning of the semester starts to become very relevant here in terms of duty to warn other people. There are two ways to try to predict future violence. One is clinical prediction, and this is where you have a judgment made by a clinician, and it's hopefully informed by research. And then there is actuarial or statistical prediction. And this is based on data and research and uses decision trees. This Grove et al. Study in 2000 found that this actuarial using the stats tends to be about 10% more accurate. And then the MacArthur Violence Risk Assessment Study argued that the best prediction of future violence is past violence. This is not shocking to anyone in psychology at all, because we know in psychology that in general, the best prediction of future behavior is past behavior. And so you use a decision tree to put people into categories, 5 low to high risk categories. And this is a good classification. So when people are put in the lowest risk category, only 1% of those people engaged in future violence. When they're put in the highest risk category, 76% of those people engaged in future violence. So what assessments do we do here? The only thing that is recommended is the psychopathy checklist revised, the PCLR that we talked about when we talked about Dexter and psychopathy. And then people will also use the MMPI-2, the WACE, the PAI, and there's a screening version of the PCL. People will use that too. Alrighty, so then we want to just talk about malingering in general. So malingering, again, is the intentional fabrication of, or exaggeration of physical and psychological symptoms motivated by external incentives. That's very wordy. I'm going to say it again. So the intentional fabrication or exaggeration of physical and psychological symptoms or psychological symptoms motivated by external incentives. So you're lying about your health, physical or mental, because you're trying to get out of something or trying to get something. You don't want to go to jail, you're in a lawsuit, you're trying to get money, right? Things along those lines. This happens a lot more often than the stuff we've already talked about. So 15 to 17% of the time, when the question is this person faking? Is this person malingering? The answer is yes. And it seems higher in some settings. So one of the reasons why, right, only a quarter of NGRI cases work is because at least 41% of folks in NGRI cases seem to be malingering. You can be coached to malinger. So your attorney can tell you how to respond to things. And Wetter and Corgans in 1995 did a study where they polled attorneys, and they found 50% of attorneys, so a full half of attorneys, and 40% of law students felt not only was this okay, but it was their responsibility to give their clients information about tests and how to avoid being detected if they were malingering. So really interesting. And again, an entirely separate set of ethics from what we have as psychologists. That's a legit question. I mean, you have to prove that they were coached, right? And that can be really hard if those conversations aren't recorded. I don't know if I can get disbarred for that, right? Because it's probably within the realm of helping your client. That'd be an interesting thing to Google if anyone wants to look it up. Yeah. So how do we detect malingering? It can be pretty tough. But we look at things like rare symptoms that even psychiatric patients don't endorse. We also look for improbable combinations of symptoms. Those with a preposterous quality, off the realm, or just like symptoms that don't usually go together in a disorder. Symptom combinations that don't make sense, like feeling like your thoughts are racing, having grandiosity, but then also like needing more sleep and eating more. We've just described mania and depression in the same sentence. Symptom severity and distress. Interestingly, people who are truly psychotic are often not distressed by their strange symptoms. Whereas people who are faking might say that they're distressed. Indiscriminate symptom endorsement. So they might just say they have every symptom you ask them about, right? That could be a little red flag there. And then obvious versus subtle endorsement. So they might only endorse obvious symptoms, but miss the subtle ones that go with these disorders. So for example, they might say, yeah, I'm hearing voices and I believe stuff that's not real, but miss stuff like flat affect, which is a very common symptom of psychosis. Reported versus observed symptoms. Are they saying one thing but acting in a different way? Yeah.
I have a question because this is like a huge thing and well, in the Navy.
Sure.
I did a lot of admin stuff, so I processed a lot of people who were medically discharged and stuff. And there was a lot of people who actually did have like medical issues and stuff, but were labeled as malingering.
Oh, geez.
So I always wondered, I was like, do the way that they look at these types of things, is it too vague? Can it be more descriptive?
Yeah, that's a really good question. Yeah, and unfortunately, in certain scenarios, it's to the advantage of the organization to deny things like that, right? So like, when you enter the armed forces, they spend a lot of time and money training you, right? So it's to their advantage to keep you. Another example, it's really hard to get service connected, which is like the equivalent of disability for PTSD at the VA. Because if you're service connected for PTSD, they have to pay for all of your treatment for PTSD for the rest of your life, right? So I don't want to say like people are purposely not, but they're probably using criteria like you're saying that are too vague or like too stringent in some ways and missing people who truly are having issues that we could help them with. So to give you an example, there was a client that my supervisor worked with when I was at the VA who had been sexually assaulted by a fellow naval officer. And it took, I want to say 20 years for her to get service connected for her resultant PTSD. Because they're like, well, you weren't in combat, so, and they're like, but she has these symptoms because of what happened to her in her service. That's a lot easier now because we know more about military sexual trauma. But yes, unfortunately, there are times when the organization benefits more from denying that, if that makes sense. Yeah, which is horrible, but true. So we have conflicting interests, right? And we certainly don't want to be like providing money to people who are malingering, because those are our tax dollars, right? But yeah, it can be very, very tricky. Very good question. Let's see. Most people who are mentally ill don't want to talk about it. So if the person seems really eager to talk about their symptoms, sometimes that's a red flag. But there's no single perfect strategy, as we were just talking about. And for cognitive malingering, that can be trickier. If they're saying like, oh, I'm having memory problems, or my intelligence is too low. You look for excessive impairment. If they're doing worse than chance, they're probably deliberately choosing the wrong items. Or you look for unexpected patterns. Maybe they are bombing both the easy and the difficult items, right? Where the easy items most people would get no problem. There are also tests we can use for malingering in particular. So the MMPI-2 I keep bringing up, because it has so many validity scales. So it has these 3 scales that are just designed to attest malingering. So F is just like, are you endorsing uncommon symptoms? FB is, are you endorsing more severe symptoms on the second half of the test? And FP is, are you endorsing symptoms that even the person who has severe psychosis isn't endorsing? So they give you a pretty comprehensive idea. So when people malinger, these scores go up. Storm and Graham studied 3 groups. They had students take it, and they gave them just the normal MMPI instructions. They had students who were instructed to malinger and coached about malingering. And then they had psychiatric patients take it with the normal instructions. Uncoached, the MMPI does really well catching anyone who's malingering, but coached, it's harder. You actually have to use lower cutoffs because they'll endorse fewer. And there are 2 kinds of coached malingering. One is symptoms. You can sort of coach someone and like, what are the symptoms of this disorder and how would you present it? Or you can coach them specifically about the test and how to essentially get past the validity scales. So if you're given more information about the disorder, those folks score more like an actual patient. But it doesn't affect the ability of the validity scales to detect the malingering. The SEERS is the structured interview of reported symptoms. And this is developed to assess malingering or feigning. And it takes about an hour to give it. And it's based on strategies for identifying malingering. This is really accurate. The classification rates are about 90% in just about all cases. Yeah, Julia.
I think in chapter 7, they were talking about polygraph testing and ways that people like try to get around.
Right.
So would that be like similar kind of way that they know it's good?
Exactly. Yeah. So yeah, it's like, yeah, it's not gonna be physiological, it's not gonna be stepping on attack, but it's like, okay, pay attention because they're gonna give you these items that people don't even endorse when they have schizophrenia. So make sure you don't say yes to those. Yeah, exactly. And like, unfortunately, because scientists are good people and we spread our knowledge, it's can be easy to get some of that. Like there are whole books published about the MMPI, right? Things along those lines. Let's see. The Sears can be impractical in routine forensic work because it does take an hour. But if you see the possibility of malingering come up on other tests, you might want to get this to get additional support. The MFAST is the Miller Forensic Assessment of Symptoms task. And it's a shortened test using the same strategies in the Sears. So it only takes about 5 to 10 minutes, much better than an hour. It doesn't have as much research support just because it's newer. And it's better at ruling out malingering than proving someone is doing it. At best, this is seen as a screening measure. And if the person seems like they're popping up for malingering, then you would give something like the Sears or the MMPI. The Portland Digit Recognition Task presents 5-digit numbers and a distractor, and then has the person choose the 5-digit number from a pair. This is a thing that people are pretty good at, but they don't think they're good at. So if people are bombing it, it can be an indication they're trying to say they have memory problems when they don't. And then my favorite is the test of memory malingering for these cognitive issues, the TOM. It was created by a guy named Tom Tombaugh, and I love it just because he's clearly a little conceited, but that's all right, Tom, we give it to him. And again, this is very similar in that it seems like a really hard test, but it's not. So there's 3 flip books, and the first flip book, you just show people pictures, 50 pictures. This sounds overwhelming, right? And then the next 2, you show them pairs of pictures and you just ask them, which one have you seen before? Again, sounds overwhelming. People are incredibly good at this. People are good at remembering pictures, and people are really good at what's called recognition, where you just have to pick the one you've seen before. So most people get close to 100%, to the point that like if someone gets 45 out of 50, you start to look at malingering. Like that's how accurate people are at this. And then clearly if it's much lower, you would look at that as well. And I'm sorry I have to keep checking my watch, but that clock is like bizarrely off now. I can't even convert it in my mind anymore. All right, last thing we're going to talk about here real quick is juvenile transfer. So forensic psychologists sometimes will be called on to evaluate youth whose criminal cases are being considered for transfer to adult court. Those evaluating juveniles for a potential transfer must focus on the risk of future offending, the interventions needed to reduce the risk, and the likelihood the youth will respond favorably to such interventions. States vary in their specification at the age at which an adolescent is eligible for prosecution in the adult criminal system, but a lot use the age of 14 or 15, so about 4 years younger than when you're actually considered an adult. There are several justifications to transfer to the criminal system. 1 is if you're charged with homicide. 2 is if you're charged with other specific violent felonies like sexual assault. And 3 is if your history of prior juvenile offending is just sort of built up. And juveniles can be transferred in different ways. So the state exclusion, the state legislature can determine that certain offenses must be filed directly with an adult court. So if you've committed murder and you're 15, you're going to be tried as an adult. The law could just say that. And then there's judicial discretion. And this is where the juvenile court can decide whether the youth should be transferred to adult court or not. And then prosecutorial discretion, where the prosecutors can decide whether cases are to be filed initially in juvenile or adult court. So is putting juveniles in the adult system effective at reducing reoffending? Because again, in theory, our prison system is about reducing recidivism, rehabilitation. There's no decline in juvenile crime after these transfer laws came into effect. And in fact, they found that housing juveniles with adult criminals may promote criminal attitudes and motives in those youth. High rates of recidivism have been observed when the youth are transferred to the adult system. And unfortunately, juveniles in adult facilities are more likely to be physically and sexually assaulted than youth in juvenile facilities. Juvenile transfer may also occur in the other direction, where juveniles are placed in the adult court are returned to juvenile court, and that's called a reverse transfer. And some 25, so half the states have reverse transfer procedures that allow juveniles in adult court to petition to transfer back to juvenile court. All righty, we got all the way through criminal assessment. We'll do civil assessment starting on Thursday.